Morning. I'm Judge Ryan Sullivan. I'm going to be handling the hearings today. And before we begin, counsel, are there any cases you'd like me to hear early on in the docket today?
No, Your Honor, thank you.
No, Your Honor.
All right. Then I will just start with the jails list. We have a bail hearing for Angel Camargo. Good morning. This case was previously continued to satisfy Marcy's law. Let's begin with the state.
Yes, Your Honor. Unfortunately, we've left a message, but have not heard back, but we're prepared to go forward today. In this case, we were asking for $150,000 bondable only bail, uh, DAS or pretrial supervision, no weapons, and no contact with the co-defendant, Eric Garcia Duran, or the victim, Hector Salazar Jaraguay. I apologize, I'm probably mispronouncing that name. The defendant has a concerning criminal history. He has a domestic battery case back in 2018. It looks like he was convicted of disturbing the peace in Sparks Municipal Court. And another disturbing the peace in 2022 that was ultimately dismissed. Had a misdemeanor conviction for drawing a deadly weapon in a threatening manner here in Reno Justice Court. That was in 23, and then had a felony arrest for possession of stolen property. Looks like it was no issued. In this case, extremely concerning. One, that the defendant has that prior drawing a deadly weapon case, given all the facts and circumstances here. Obviously concerning, given the indications by witnesses that there were gang signs being thrown, that there was comments about gang involvement prior to this incident. And also, as laid out in the probable cause sheet, that the defendant was quick to flee to his vehicle to obtain a firearm and provided a firearm to the other co-defendant. And there were multiple shots fired with many witnesses and innocent bystanders around as well. So this is an extremely concerning incident. We believe that it poses a high risk to the community, especially given the defendant's prior firearms violations, and that bail and conditions are appropriate. Thank you.
For the defense.
Your Honor, what you did not hear are any felony convictions for Mr. Camargo. There are, I believe, 2 misdemeanor convictions, and no indication that he has failed to follow through with any sort of court obligations, no failures to appear in those prior matters. Understanding that the allegations in this case are serious. However, there's simply no evidence that Mr. Camargo would fail to appear and handle any future court appearances and comply with terms and conditions of supervision. In addition, he came in at booking, was scored by pretrial services at a 7, giving points for a place to live and employment. We were able to speak, our investigators were able to speak to a reference, a former partner who verified his address and that he lives with his mom. He is also on the lease with a girlfriend. He works for Pacific Stone. And so that would bring his risk score down into either the low end of the moderate range or the high end of the low range, depending on how that was finally scored. But the takeaway point is that it would be reduced from a 7. So we have someone who has strong ties to the community, residence, employment, family, no evidence that he has failed to appear for court dates. And so bail outside of his means is not the least restrictive option available to the court. He is not able to post the amount of bail sought by the state. If the court felt, given the nature of these charges, that some money bail is appropriate, we would ask for $10,000. Bondable, even that would be a challenge for him to post, given that he's been incarcerated and not able to earn money while he is incarcerated. He would abide by the no contact orders with both the his co-defendant as well as the alleged victim, and show up for future court appearances and comply with any supervision conditions ordered by this court.
So Mr. Camargo's 25 years old. He already has a conviction for drawing a deadly weapon in a threatening manner, and the other misdemeanors, disturbing the peace as well. And the details of the probable cause narrative show alleged actions that were very dangerous to the community, not just the individual that was shot and that had to have surgery as a result and could have easily died, but all the other people who were around in a crowded area near a bar where previously other individuals had tried to separate these groups of people and get them to simply leave. That was also in the probable cause sheet, and the evidence in the PC that Mr. Camargo then went to his vehicle to retrieve the weapon and continued to engage when there were allegedly plenty of opportunities to stop and just leave without that happening. Therefore, I think monetary bail is appropriate. I'll take into consideration the 7 on the risk assessment and set it at $100,000 bondable only. He'll have no contact with Hector Salazar Wageri, no weapons and supervision by pretrial. I'm not going to include no contact with the alleged co-defendant because I want, if they're both in the jail, I want the jail to be able to house them as the jail sees fit. Thank you. Next, we have Eric Garcia Duran. Good morning. This was also continued to satisfy Marcy's law. Let's begin with the state.
Yes, Your Honor. So with Mr. Garcia Duran, the state acknowledges that he has an MPRA score of 2 and no prior criminal history. However, we are still asking for $100,000, slightly less than the co-defendant, given the lack of criminal history. However, the danger of the community is still extremely concerning to the state. Again, and just for the record, the defendant was engaged in this argument or verbal altercation, could have left. Concerningly, there were references to gang and gang involvement prior to the shooting. What is also concerning, especially about this defendant, is that as laid out in the probable cause sheet, it indicated that Mr. Garcia Duran fired at least, according to the probable cause sheet, was holding the gun above his head, firing at least 8 rounds indiscriminately before who I believe was a security guard who was videotaping it, essentially ducked for cover. And the probable cause sheet indicates there's a lot more gunshots that are heard. This defendant, in the state's view, is absolutely a risk to the community. This was an incident where it was outside a bar, many innocent bystanders around, and to have an individual who was part of a group that was actively trying to engage in a fight with an individual who was retreating, firing indiscriminately around, striking, again, the probable cause sheet indicates that buildings and other objects were struck in the area. Frankly, the fact that there was only one, although one is too many, one victim who was shot is probably, frankly, a miracle, given especially Mr. Garcia's apparent indiscriminate firing. The state's view, he's absolutely a risk to the community, and we would ask for DAS supervision and no weapons. Would ask for no contact order. Again, I understand the court's position, but I would just put it on the record. And with that, I'd submit it.
For the defense.
Your Honor, I also believe that Mr. Garcia merits a lower bail in consideration of his lack of criminal history. He scored on the MPRA for his age and at first arrest, which is this one. It is his first lifetime arrest, and for not having a verified phone number. We were able to reach out to his family. They verified that he's been living in Washoe County for the past 11 years. And he's been working at a cleaning company for 1 year, stable. He's been at the same address for 3 years. And that he has been employed with that cleaning company. So, theoretically, he could be released to house arrest. We do understand, however, that this has serious implications for the community, and the state has some valid concerns, and the court has some valid concerns. So Mr. Garcia understands that monetary bail is most likely appropriate. We're asking that the court consider his lack of criminal history, and his age when determining what his bail should be set at, as well as his financial status working at a cleaning company. We're asking that the court consider setting his bail at $50,000 rather than $100,000 bondable. He is willing to be on house arrest and any kind of supervision that the court thinks is appropriate, and obviously have no contact with his co-defendant if that's what the court thinks is appropriate, although I understand the court's position on jail safety, as well as, like I said, house arrest, staying away from anybody that the court thinks it's appropriate for him to stay away from if the court wants to impose like a no known gang members affiliation clause or some other kind of restriction on his movement. He's willing to submit to that.
Thank you. So Mr. Garcia Duran does not have any criminal history. He's a bit older, but again, this act and these allegations are very serious. Not only was someone almost killed who had to have surgery, but again, as stated in the probable cause sheet, there were numerous people in the area, and previously other individuals had tried to stop this and get the two groups to separate. And the allegation is that both Mr. Camargo and Mr. Garcia Duran then went to the vehicle, got weapons, and returned to continue what had already been started. So I think there is a significant risk to the community. I will take into account his low risk on the risk assessment and his lack of criminal history. I'll set his bail at $65,000 bondable only, no contact with Hector Salazar Wagaray, no weapons, and supervision by pretrial services if the bond is posted. Thank you. Next, we have a first appearance for Achilles Burgess. Good morning.
No.
I believe counsel, probable cause has been found, public defenders appointed. Let's begin the bail hearing with the state.
Yes, Your Honor. In this case, we are asking for $25,000 bondable only bail, pretrial services supervision, no contact with the victim, Brian Brandt, and no weapons. So I acknowledge he has an MPRA score of 3. It appears that his criminal history is for a failure to appear for traffic in Clark County. That is a sole criminal history at this point. However, again, in the state's view, if you can't show up for the little things, I think that's indicative of whether or not you will show up when there's more serious penalties on the line. Additionally, the concern here is frankly that this appears to be just wholly unwarranted. The defendant, I think the statements in the probable cause sheet from the girlfriend or the associate of the defendant who was there said she was shocked by his reaction. Essentially, this was over whether or not the DoorDash guy brought his ice cream or not, and his response was to pull a gun and chase him into the parking lot. And so this, in the state's view, in addition to the concerns given the failure to appear on the minor traffic violation in Clark County, which does appear to be a Clark County only warrant, just the escalation of violence for something extremely trivial, in the state's view, shows a risk to the community if he was willing to chase someone with a gun across an apartment complex parking lot over ice cream. So we believe that bail is appropriate and ask for those conditions as well. Thank you.
For the defense.
Thank you, Your Honor. The incident in Clark County involved a traffic citation. Mr. Burgess indicates that he was in an accident and his health and finances prevented him from taking care of that ticket right away. And then he had moved to Washoe County. And so he understands he still has that ticket outstanding. With regard to the weapon in question in this offense, as is noted in the probable cause sheet, it belonged to the other resident of that apartment and was surrendered to law enforcement. given his very low score on the MPRA, his ties to the community, his personal information was verified. He did receive 1 point for a job. He indicated that he has been awaiting confirmation for Tesla, and he's in a stage of flux with Tesla, but also looking to has applied to Panasonic, so has a work history even though he does not currently have a job. So again, still stability with the community, a way for the court to contact him, appear for future court dates. The firearm in question is no longer in the home, does not belong to him. A no weapons, a no firearms clause would be absolutely appropriate. But that would be, an OR with that condition would be the least restrictive option before the court today.
So this is a hard decision to make because I agree that this allegation seems very random and concerning. However, he has no criminal history other than missing the traffic date, and he scores a 3. So, Mr. Burgess, I believe that Valdez Jimenez compels me to release you, but your case is not over with, sir. And if you miss this court date or get arrested again for anything else, the court can certainly hold you in jail the next time. Do you understand that?
Yes, Your Honor.
All right, so he's going to be released, no contact with Brian Brandt, no weapons, and you're going to be supervised by DAS. Make sure you know how to start your supervision, because if you don't start that, they immediately let the court know and you can be returned to jail. You also have to show at your next court date. It's going to be December 4th at 9 a.m. Make sure you're here. And again, start your supervision. Thank you.
Right here.
Next, we have a first appearance for Tanner KG.
Sorry, I'm sorry, Your Honor, I didn't hear who you called.
Tanner KG, K-A-G-Y.
And Your Honor, we are asking to waive his appearance. I'm prepared to go forward. He's quite ill this morning, but we were able to speak with him.
All right. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Yes, Your Honor, if I could maybe have defense confirm if they know. So the name on the PC sheet is KG, K-A-G-Y, but the criminal history shows as Casey, K-A-S-Y. I understand we're not to arraignment true naming yet, but I don't know if the defense has input on if it's Casey or KG.
We do, Your Honor. I did notice that discrepancy, and our client confirmed that it is K-A-G-Y, KG.
Okay, thank you. So, Your Honor, on this case, we are asking for $10,000 bondable bail, DAS supervision, testing for alcohol and controlled substances, and no weapons. The defendant is 18, quite a young man, and probably as a result of that, well, I guess I would just note that I don't show any criminal history, although he scores a 6. Reason why the state believes that bail is appropriate is one, just the violence level here. Understand the defendant gave a different version of events when he was spoken to. However, I think what the video shows regarding the defendant striking the victim with a rock and continuing to punch him as he was trying to get in the house shows a level of violence that's concerning. And then also with the unclear what exactly he was using the controlled substance for, the prescription drug, but obviously the prescription drug was on his person when he was contacted. Additionally, it appears that the defendant has a general lack of stability in the community as far as residence and where to go. And so therefore, we believe that that makes him a risk to not appear. And so based upon the violence here and the risk to the community that poses and his risk not to appear, we believe that $10,000 bondable and those conditions are as appropriate. Thank you.
Other defense.
Thank you, Your Honor. We were able, so as indicated earlier, that Mr. KG is experiencing detox symptoms and is quite ill. The prescription medication, the 1 pill sertraline, is the generic for Zoloft, so a medication used to treat mental health symptoms. We were able to speak with his mother this morning to verify some additional information. His family's been quite concerned about him. He has some untreated medical issues, and his mental health has been deteriorating in addition to a clear concern regarding his opiate use. They had tried to take him to the Mallory Center in Carson City, and they've been trying to get him services. So if the court is inclined to impose a bail, we would request an alternative to an inpatient treatment, given his level of use and the collateral information. If he is able to post bail, again, he's not going to be able to, given his lack of resources. He would try to stay with his aunt. It's our understanding he's been discharged from the Eddy House, understands that he would be required to stay away from that address, as well as the alleged victim, and he would comply with that. So, Your Honor, in the alternative to money bail, we would request an order to an inpatient substance use disorder program.
Thank you. So this is a violent act. It appears to be, from the video, unprovoked. I understand that Mr. KG indicated there may be some incidents that happened earlier, but not at this time, it doesn't appear. And he still scores a moderate, even though his criminal history, there's nothing there. So I think that monetary bail is necessary due to risk to the community. I'll set it at $8,000 bondable only, no contact with Bowen McCarthy, supervision by pretrial services, no weapons, and testing for drugs and alcohol. And I understand the request to release him to a facility, but I simply am not willing to make that determination at this time. Frankly, I'd like to see what he's actually charged with before making that determination.
Yes, Your Honor.
Next, we have a first appearance for William Louis.
Good morning, Your Honor.
Morning. Probable cause has been found. Sir, you've indicated you're going to hire your own attorney. Were you able to reach out to anyone?
I have my wife working on that.
Okay, but you've not had conversations with anybody?
No, ma'am.
All right. Sir, tell me, how much income do you make per week?
About 1,300.
And how many people are in your household?
5, including myself.
Okay. So, sir, based on that, you do qualify for the public defender to represent you, so I will appoint them. You're welcome to hire anyone you like at any time, but I believe based on your income and the number of individuals in your household, you qualify. So let's begin with the state.
Yes, Your Honor. So with Mr. Louis, I show that his only criminal history is from 2013 for possession of less than an ounce of marijuana in Las Vegas. He, according to paperwork, appears to still live in Las Vegas. So that is somewhat of a concern. However, given the what is set forth in the probable cause sheet, as far as the firearm being in his pocket the entire time, I think what we're dealing with primarily is the CCW issue, and an otherwise kind of mutual affray situation. Obviously concerning when an individual has a firearm and continues to consume alcohol, though I think the PBT at a 0.08 is what the only testing that I show, which is not above the statutory limit. Given that and the remote criminal history and the score of 3, I would not object to an OR. We would ask that he be supervised, given his out of the area likely residence, to make sure that he is keeping up with the court and appearing in the future, and then also that he possess no firearms during the pendency of this. If he has any other firearms, we'd ask that he either surrender them to DAS, or if he's living in Las Vegas, I'm not sure if like the sheriff's office down there would accept, or he can file an affidavit saying he's provided any other firearms to a third party that he owns, while this case is pending. With that, I'd submit it.
So I do believe Mr. Louis qualifies for his own recognizance release. He scores low. There's no criminal history. It's not an allegation that he used the weapon at this point. So I will release you. But Mr. Louis, your case is not over with here just because I'm releasing you. You can't go back to the Grand Sierra Resort. You need to stay away from that place. And you can't have any other weapons. I'm also going to set your next court date. It's going to be December 4th at 9 a.m. here in Reno Justice Court. There are ways for you to handle this either remotely or otherwise, but you need to talk to your attorney about that because you have to make sure you fulfill all your court appearances and obligations. I'm not going to place him under any type of supervision, but Mr. Louis, make sure you follow through with all these things and show up at your next court appearance.
Thank you, Your Honor.
Next, we have a first appearance for Tanya Miller.
Okay, thank you.
Good morning, Your Honor.
Good morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Yes, Your Honor. With Miss Miller, we are asking for $7,500 bail. I think it'd be appropriate to set it at bondable bail given the assault with a deadly weapon. Miss Miller has a criminal history going back to 2018 with a misdemeanor conviction for obstructing in Reno Municipal Court. She had a disturbing conviction in 2019 that was down from domestic in Carson City, had a failure to appear arrest in Reno Municipal Court also in 19, and a misdemeanor trespass conviction in Reno Municipal Court in 19. Then she had it was a entry for a misdemeanor conviction for violation of a condition of suspended sentence in the 5th Judicial District in Nevada. I couldn't see what was underlying that, but that was the entry in her criminal history in 2019. 2020 had a violating a probation in Carson City. That was a conviction, I assume, from the disturbing case. 2021 had a misdemeanor conviction for domestic battery. 24 had a misdemeanor conviction for obstructing. And then she had a trespass case earlier this year in Sparks Municipal Court that was dismissed, and a failure to appear arrest after that. It looks like she had failed to appear and then was ultimately dismissed. So given her score of 12, we do believe that bail is appropriate and risks the community given prior violence convictions, as well as what appears to be some issues with complying with the courts. We would also ask for no contact with the victim, Patrick Douglas, and no possession of weapons, given the allegations here. Thank
For
you.
the defense.
Thank you. Start with those last couple of conditions, the no contact order, no possession of weapons. Those are appropriate, and Ms. Miller would have no issue complying with those requirements. For Ms. Miller, her primary issue is a very serious alcohol use disorder, as is indicated in the probable cause. Or maybe it's in the pretrial services report, but her blood alcohol was at a 0.2 at the time of intake, which is certainly dangerously high. She indicates that she had previously maintained sobriety for about 2.5 years, had graduated from Crossroads. She has been under the services of WellCare and is close to obtaining a bed through the Puff House and WellCare services. Her doctor had previously recommended that she obtain medication-assisted treatment, and she had unwisely been essentially white-knuckling it and believing that she could maintain sobriety on her own. She clearly cannot, and now is articulating some insight as to taking advantage of that assistance for medication-assisted treatment, in addition to following up at WellCare. She would return to the CARES campus. And to the best of my reading, this happened off of the campus, and so she should be eligible to return to follow through with placement at WellCare to get much needed services again. When she is not intoxicated, she does not pose a risk to the community and is not at risk of failing to comply and appear for court attendance. She would request alcohol testing Whether that, in her case, it might be appropriate for that to be daily, given the level of alcohol use that she has. And so with that level of supervision in terms of very strict alcohol testing, obviously a no alcohol clause and enforcement of those requirements, following through with her treatment in the community, that would be the least restrictive option before the court this morning.
So she scores highly on the risk assessment, and Mr. Douglas is a particularly vulnerable victim. He's in a wheelchair and is a double amputee. And this is a violent allegation of someone who has a lot of history. Not all of it is serious as this allegation, but I'm still concerned also not showing up to court. Therefore, I think that some monetary bill is necessary. I'm going to set it at $5,000 bondable. No contact with Patrick Douglas. No weapons. Testing for alcohol and supervision by DAS. I will include a direct transport to a residential treatment center or any kind of treatment. I also want a her court referral done for Miss Miller. So our clerks will start the her court referral process, and she can be directly transported to a treatment bed. But otherwise, that's the bail set and the conditions. Thank you.
Your Honor, may I double check the date for the 72 hours? I have two different dates in my file. If I could just double check that with the court.
Yes.
If it's the 21st.
Our clerk will know the answer to that.
Oh, hold on a sec. It'll be the 21st.
Okay.
Sorry
Thank
if I put it wrong dated.
you. No, it's all right.
Next, we have a first appearance for Alexander Soraya.
Means you're in the unless you can get to a program or post bail. Okay, so you're yeah.
Thank you, Your Honor.
I'm so sorry, I didn't hear the name that you called.
Alexander Soraya.
Your Honor, Mr. Soraya waived his appearance, and we would submit on bail as appropriate, Your Honor.
All right. This is an ad book allegation. Probable cause is found. Public defenders appointed. Given this submission, what is the state's recommendation?
Your Honor, we're asking for an additional $10,000. We'd also ask for, again, a no contact order pursuant to NRS 178, understanding that's what we're here on essentially. And no weapons, given the concerning nature of all of these activities with the burglary and the home invasion, and now this again, and DAS supervision.
That's what it'll be. $10,000 bondable, 10% cash, no contact with Kyra Foley pursuant to statute NRS 1784845, no weapons. All prior conditions are remaining in effect for his underlying case, and he'll be supervised by DAS. We have a first appearance for Ashley Penman Gillespie.
Good afternoon, ma'am.
Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Yes, Your Honor. So with Miss Penman Gillespie, I show that she has no criminal history. She's got an MPRA of 6, which is somewhat concerning. However, I'd note from the report that she essentially eventually fessed up in this matter. So based upon her actions, her young age, her lack of criminal history, I don't have an objection to an OR with her. I would ask at this point for no contact with Josh and Katrina Penman. Unfortunately, I've been unable to get in touch with them about this, but we would ask for that in at present, unless they would like to readdress that, and I'll have my investigator reach out if that's the court's order to let them know that that's the case. I understand they live on the essentially same parcel in different houses. I would just ask that that be a condition, and not the 100 yards away. I don't think that's applicable, but no contact by phone or in-person conversation. And then DAS supervision, given that she's a young woman and this is her apparently first time in the court process, and just to have someone to check in with so she can appear at future court hearings and deal with this matter. Thank you.
So ma'am, I'm going to release you, but your case is not over with. I'm going to give you your next court date. It's going to be December 4th at 9 a.m. You cannot have any in-person contact or through phone or email or text with Josh or Katrina Penman. I understand they live very close to you, but you cannot speak to them, even if they reach out to you. You cannot speak to them or otherwise have contact with them about this case while it's pending. And given the no criminal history, I'm not going to put in place any other orders besides show up to your court dates, don't get in any more trouble, and no contact with those folks.
Yes, ma'am.
Thank you. Next, we have first appearance for Amber Watros.
Okay, thank you.
Good morning. Probable cause has been found and the public defender is appointed. Let's begin the bail hearing with the state.
Your Honor, this one I would ask for continuance for Marcy's Law. We've been have not yet been able to get in contact with the victim in this case, and so we'd ask for another day.
All right. So pursuant to Marcy's Law, the state has a right to reach out to the alleged victim and get their input for this hearing. So to comply with that law, we'll hold this bail hearing tomorrow morning. Thank you. All right, counsel, I believe that was everyone. Any questions or anybody I missed?
No, Your Honor, thank you very much and have a great rest of your day.
All right. Thank you. You too.